The Juvenile Court Act was created for abandoned juveniles. And I know that, I understand that, I can read that because it's clearly stated within RCW 1334 in number 1 of the definition section. It says abandoned, and it says that the child has to be abandoned for 3 months. A lot of parents are too traumatized to read their court documents. This is pretty much what we bet on, because that trauma blinds them from the fact that they never abandoned their child and they don't know that. Okay? What we do when we get their signature is get them to agree to abandon their child. So they're agreeing to give their child to a foster home, basically, every time they sign a dependency order, and they don't even know it. They believe that they're going to get their children back if they sign it, but there's no reunification laws within RCW 1334. It defines an abandoned child, and it is the only section of law that will terminate a parent's rights. So that means that a child has to be abandoned in order for the rights to be terminated, no matter what. Because RCW 26.44 does not have termination statutes, and that is where the abuse and neglect laws are. So basically, the only reason RCW 26.44 is included in 1334 is because an abandoned child is abused or neglected because it's abandoned. Okay, that's the only reason it is included. But that section of law was made for abandoned children only, and the child has to be declared abandoned in order for us to terminate the parent's rights. Okay, there's no such thing as an appeal. Under RCW 1334-200, there's no appeal. A termination order is final. That means that all of the orders prior to are agreed. That means they can't take anybody's kids unless the parent agrees to the order prior to the child's removal, which is actually required because RCW 1334-130 says that a fact-finding hearing has to happen first before the child is taken out of the home. But nobody knows that because a shelter care hearing is what it is. It means the juvenile needs shelter. That's why it's called a shelter care hearing. So the child has to be abandoned. And that's why it says that they can take the child into custody and not from the parent's custody in RCW 1334-050. It also says in RCW 1334-055 that nobody can have physical custody of a child that's placed in shelter care, which would make sense because, like I said, it's called shelter care for a reason. The child needs shelter, and anyone can file a dependency petition. Not anyone can file and get a warrant. So warrants are defined under the law to be able to remove physical custody of a child from a person, and they are under RCW 26.27, which never is cited by a DCYF to remove children. They actually only use dependency petitions, which they're not supposed to be doing, to remove physical custody of a child from an actual person. They have to use a warrant because physical custody is defined under RCW 26.27021. And this is the Uniform Child Custody Act, which also applies to dependency and termination. However, in order to force the child into adoption, they have to declare the child abandoned. Otherwise, they cannot do adoption and get adoption assistance or Title IV-E funding. So they have to allege abandonment no matter what. But these parents don't know that. They're actually being told that they're going to get their kids back if they complete services when the parent is not the defendant, the juvenile is. So the parent doesn't have to do anything. Okay, and they can't prosecute the parent, they can't hold a trial against the parent or anything like that, because what would they be being charged with? There's no child abuse laws that allow them to basically force parents into rehab until they get better and then to protect the child from future abuse. That's completely unconstitutional and not allowed. But what we did was we added words to the law in the court form to make it look like we're allowed to select from a list. Under RCW 1334-0306, A, B, and C, there is no or until after option D, but we added an or after option B so that we could pick from different situations to be able to remove the child from the parent. And the parents usually believe what we show them on the form, that we're allowed to pick, because we added the or. We create the court forms for the entire state of Washington. And since we already are judges and we pretty much make the law with every ruling, then we figured, why not make the law with the court forms? I mean, we're not legislators, but we did it. We've been doing it for years, and we know that that section of law only defines an abandoned child. But we don't care, because we're just regulating parental conduct. That's what we've been doing for like 25 years. This is why CPS can't kick the door down, because they're not using warrants. If they were using warrants and doing it properly, they still wouldn't be able to take the child into a foster home. Why? Because no statute says that they can. The statute that they've been applying only says that the cop can take the child into custody. And the other statute, RCW 1334-130, underneath that section, it says that the fact-finding hearing has to happen first. If that's the case, then that means the parent has to agree first. And in most of these cases, the parents don't agree until after the child is removed. But we just don't say anything. We just pretend we know what we're talking about. And we created 2 court rules that contradict the law completely. And these court rules say that a parent is allowed to appeal a fact-finding trial and a termination trial when there's no such thing under the law as either. And it contradicts RCW 1334-200, which says a termination order is final. And the fact-finding hearing statutes also do not dictate any type of trial or say that the parent can contest a fact-finding. That's not allowed either. These are called agreed dependency orders for a reason. And the CASA is there to stand in the place of the parent. That's why she's so important. It has nothing to do with her being important for any other reason but that she stands in the place of the parent and is supposed to have the closest relationship with the child. But the parent's not supposed to be there. Otherwise, you would see things like bio parent, those kind of words within the statute. You don't see those words. They don't separate the parents because there is not a separation of the parent from the child. There would be way more laws involved if this were in fact allowed. They would have laws regarding who gets to file taxes, how much time, they can spend away from each other or be apart from each other. There would be way more laws involved. This section of law was made for abandoned juveniles and for their rehabilitation, not for parents. But we are good at pretending we know what we're talking about. And since we created those court rules, it pretty much kind of makes it all valid, really. But technically, an appeal in a trial has to be written in the law, and it's not. Only criminal trial is written in the law, and civil trial also, but in the superior court. As far as the Supreme Court goes, we have no jurisdiction over the parent as a defendant in juvenile court. That's why we don't make our rulings on the record, because we know we're breaking the law. We've been doing this for so long, it's like we can't stop now. Too many parents have been separated from their children. We would have to go back and it would be impossible to stop now. Like hundreds of parents have been separated under no laws at all. Everything a state official does, even a judge, it's written in the law for them to be able to do it, basically. So if there's not a statute, then we can't do it. So if reunification doesn't exist under any part of these laws, then that means they can't send the child home if they wanted to. As a matter of fact, they can only dismiss the case. And when do they dismiss? When the child's 18, that's when they dismiss. So basically, yes, it's been getting done wrong for a very long time. If these laws were created to rehabilitate parents, there would be reunification statutes that instruct them on when the child gets to return home, on, how the child gets to be returned home. It would not just simply be dismissed, because dismissing isn't the same as sending the child home to the parent and the parent regaining custody. There are no laws within this section that explain how that would happen. And there has to be these laws in order for them to actually do it. Otherwise, they don't have to do it. And I'm sure they've done it before because, some people they like, some people they don't like. But these laws must exist in order for these things to take place. And they just simply don't exist. This is why parents are being, basically fooled into believing that they're going to get their kids back, but they really aren't. And the title of the section of law is dependency and termination. The word "and" means termination is included. It's not dependency or termination or reunification. There's no, none of that there. So it's not created for parents, it's created for juveniles. A long time ago, parents used to be able to sign their kids to the state if their kid needed rehabilitation for whatever reason, for to go to drug treatment or anything like that. And that's what it was used for. For example, the Shermer case, the one that we made up out of our own brain, that, where the kid is being bad and everything, and the parents couldn't afford to put him through treatment and they couldn't handle him anymore. So they were able to sign a dependency to have the state take control of the child because they couldn't do it anymore. That's when a parent agrees to a dependency. But technically, the clues in the beginning kind of give it away. Like, why do we have to give a parent notice? We have to give a parent notice because the parent's not there. So if the parent was there, it would say that they could take the child from the actual parent. A warrant has to be specific, and it has to state that in the law, or they can't do it. Everything is authorized by statute. So they've been basically doing it anyway, but nobody knows because these cases are sealed from the public. As far as, the dependencies go in the state court, the court hearings are public, but the documents are sealed, so nobody knows what we're doing, which is good for me.